I guess I'm an easy punching bag. I'm not a politician. I don't have the backing of any political party. So all these people who were there are any number of members in the cabinet, current cabinet, who were members of the Dr. Mahathir cabinet, who whenever they saw me and all were very excited. They said, you are doing the right thing, charge and all, but they are silent now. I can't understand that, you know.
Welcome to Straight Talk. Today I'll be sitting down with Tan Sri Tommy Thomas, the former Attorney General, who is very much in the news these days. As you know, it was during Tommy's time as AG that the likes of former Prime Minister Najib Tun Razak and current Deputy Prime Minister Zahid Hamidi were charged with dozens of counts of corruption, abuse of power, criminal breach of trust, and money laundering. At that time, if you remember, there was great public jubilation that finally action was being taken after years of impunity. In my view, it was one of the high points of the second Mahathir administration. And I remember so well how Malaysians were so glued to their televisions as they watched the raids on Najib's home and the stash of jewellery, watches, handbags, cash that was seized by the police. However, since the fall of the PH administration and the subsequent resignation of Tommy Thomas in February 2020 and the untimely death of lead prosecutor Gopal Siriram in January last year, there has been an unraveling of much that was previously achieved. If you recall, Zahid Hamidi was granted a DNAA last September. Najib received a partial pardon and was granted a DNAA in another case just last month. And as these cases continue, there appears to be a concerted effort to paint him, Najib, as a victim of political prosecution. People are wondering, might further DNAs be forthcoming? Tommy himself has been accused of being incompetent, of prematurely rushing to file charges, and even of leading a witch hunt. With all these things going on at this particular time, there's no better time and no better person to talk to than the man himself, to get his side of the story. So, Tan Sri Tommy Thomas, welcome to Straight Talk. With me today is also the very respected Malaysiakini columnist P. Gunasegaram, who has written extensively on the 1MDB affair. His book, 1MDB, The Scandal That Brought Down a Government, which was published in 2018, was a bestseller. Guna, thank you for joining me.
Welcome, Dennis.
Okay, let's get started. Tommy, you were not the first AG, and neither were you the last. Other AGs, when they retired, went on to obtain lucrative appointments, in GLCs and other government bodies. Just yesterday, one of your successors got appointed to a pretty important position. You, on the other hand, have been hounded at every turn. You have been investigated, you have been sued, there's been a commission of inquiry, and there's the threat of the RCI now hanging over you. One former PM, you might remember, even boasted of providing bullets to nail you. You seem to have stirred up a hornet's nest. Many ordinary Malaysians, on the other hand, seem to think that you're a hero, one of the few senior officials who did his job without fear or favor. I still see comments in Malaysiakini and all the other places praising you for your courage, conviction, and professionalism. So my question to you is, why do you think you have become such a controversial figure? Is it because you went up against some very powerful people? Was race or religion an issue? Did it have anything to do with it?
Well, thank you, Dennis, and thank you, Guna, for inviting me to this dialogue. I'm very grateful for Malaysiakini for providing us these facilities and hosting us. To answer that question, even during the 20 months that I was in office, I was often in the press for the wrong reasons. And of course, thereafter, they left me alone for a little while till the book came out, which was itself about 3.5 years ago. And then the negative publicity returned. And then I think every time there is a DNA or a dropping of a case against some accused that I charged, the controversy reverts. I guess I'm an easy punching bag. I'm not a politician. I don't have the backing of any political party, and I guess it helps that I'm in the minority. I belong to the minority race, minority religion, probably various reasons, and I think partly also because I seldom respond. These comments don't provoke me, and in fact, this is the first interview I've had for years. I've always declined invitations from the media.
Yes, in fact, I was going to ask you, why have you been so quiet? You have, Shafi, who's a lawyer for Najib, has been doing road shows and going on, and the statements from Najib have been coming out strong and widely covered, but you've been very quiet. Why have you been so quiet?
Well, I think the main reason would be to allow my successors and those in office to say things if they wished, because it mustn't be forgotten that the public prosecutor, the Attorney General and the public prosecutor, but let's look at his capacity as public prosecutor in criminal matters. He represents the people of Malaysia. That's why he's known as the public prosecutor on behalf of the public. So in the US analogy, it is the people of the US. So it's people against O.J. Simpson, the people against Donald Trump. In the United Kingdom, it's the Crown or Regina against John Smith or Adams. In Malaysia, it has always been PP. But it's often forgotten that you are there on behalf of the people of Malaysia. And in fact, the entire AGC secure their salaries and other benefits from taxpayers' monies. So the taxpayers of Malaysia fund the AGC. And therefore they have a responsibility to the wider public of Malaysia. And I would say that, and I certainly try to do that, as part of that function is the obligation to be transparent and open and accountable in major decisions. In either major decisions you take or you don't take, because sometimes omissions have as important repercussions. So when I took office, there was no tradition or culture in the AGC to issue press statements. And I started that. So in the 22 months that I was in office, we issued 36 press statements, most of which are under my name. And I believe it's still on the website. But unfortunately, my successors have not continued the tradition. So what has happened, the result, the outcome, is that one side of the adversarial litigation system, that is the accused or the defense and his lawyer, is forever making press statements, television interviews, road shows, or whatever they do. They are always in the public limelight. This is despite, in the SRC case, they lost on four occasions, and only one judge along the way supported them, and he's convicted, he's serving sentence. Despite that, there is such a large amount of publicity that they generate. And there's a vacuum, because the public prosecutor's office is not responding. And I was hoping that they would respond from time to time.
Why do you think they haven't responded?
You have to ask them, but I would say that there's a culture of being quiet. There's a tradition. Don't forget, all the 1,600 members of the AGC are civil servants. You join the public service. So I guess, and you will know, Dennis, you were a civil servant before. I think civil servants are conditioned very quickly to remain quiet, to remain silent. They allow their political masters to make the statements. But in the case of the AGC, we haven't had a political attorney general serving in the cabinet for decades. So the career Attorney General must, in my opinion, has an obligation, particularly in public interest matters.
You had one major public interview. This was after the SRC case was decided at the federal court. This was in September 2022 with James Chai and me for Malaysiakini. So in that three-part interview at that time, you said that, among other things, the federal court cannot be held to ransom over the decision. So I think that
just remind me the context. What did I mean by saying the federal court cannot be held in ransom?
So the federal court had no option. You cannot hold the federal court to ransom or blackmail the court. I'm sorry, this is an adversarial system. I always use a sporting analogy. You come for a game of badminton in the finals, and one team does not want to play, complaining about the referee. The match is over, it is forfeited.
Oh, I think it could be in the context. The question must have been, how would you comment on the federal court finding him guilty and sending him to jail because the adjournments were denied and their arguments were not, they say, not heard on the merits. But then and I stand by those answers. But don't forget, Najib applied for a review of that federal court decision, and the review was heard by a different panel of the federal court judges, 5 different judges. And I must just tell you that the review jurisdiction only developed about 20 years ago in Malaysia after the Pinochet series of judgments in the House of Lords, because historically the apex court was the final court. And litigation ended. There must be finality to litigation. So in the UK, it ended in the House of Lords. In India, in the Supreme Court of India. In Malaysia, in the Supreme Court of the Federal Court. But in the last 20 years, you have the limited review jurisdiction. Najib went for that. And on a 4-to-1 basis, the 4 majority judgments, or 4 judges said that it was his fault, that he had justice. And they dismissed his review application.
Can I turn to the IPIC case, because that's very much in the news now. As you know, both Najib and Yuan were granted DNAA, and of course that has created a great deal of concern, public outcry even. And as part of all that, some are saying, making the accusation or allegation that it was due to your negligence, your incompetence, that you rushed to lay charges without sufficient grounds, that you were politically motivated. How do you respond to those allegations?
Now I have to go back to September, October 2018, when we were appointing lawyers in London. The lawyers in London also said, look, it looks as if there are criminal aspects of it, because that's part of your complaint. Are there any crimes committed in Malaysia? And we said, and we thought so, yes, we did. And what happened was, luckily for us, Sri Ram, who had been appointed special prosecutor and took office on 1st of September 2018, he was tasked as special prosecutor to go and help in looking at all these matters and to advise, because they are white-collar crimes, they're quite difficult. And he looked at it and he spent a lot of time, and then he came back and said, in his opinion, and he had a team. He marshaled a team of DPPs from the AGC who he could work with. And at the end of September, Sri Ram came to see me and said, yes, we have a strong case. And in fact, I've taken the liberty of drafting 6 charges. So I said, leave it with me. And I looked at it. Then we had, Sri Ram and I had a couple of discussions. And then I was satisfied. And then I charged Najib and Yuan for 6 counts of criminal breach of trust of up to 6.6 billion ringgit. And essentially, the criminal charges that we instituted under Sri Ram's leadership, but I took the final decision, was to say that in order, and don't forget, these things were happening in 2016, 2017 as part of the consent award, while Najib was still Prime Minister and Yuan was the KSU of Ministry of Finance, the top civil servant and the top minister. And what they did was, in order to pay for the guarantee that they had agreed to on behalf of Malaysia, they had to divert funds. So the criminal charge of 6.6 billion, the 6 charges, and they're all in the public record, was for different amounts where the Minister of Finance and the KSU diverted funds for that purpose. And that in law would be regarded as criminal breach of trust. And so those charges were made in October 2018. And as I said, I was advised by Malaysia's greatest criminal lawyer, and with a team of MACC, everybody investigating and reporting to him and preparing. And then what happened was, at that time, Najib was already charged in the SRC for 42 million and the Tanore 1.6 billion in his bank account. And of course, he had 2 other charges. So what that meant was, you had the same accused, Najib, facing 5 separate criminal prosecutions arising out of 5 separate crimes and transactions, defended by the same lawyer. So what that meant was, obviously, and our law requires the accused to be in the dock, obviously all those 5 trials could not take place simultaneously. And so we reached a priority with the courts, very much driven by the prosecution. Of course, the defense wanted everything adjourned, but we pushed, and the order was given: SRC first, Tanore second, everything else pushed back. So that is why when I left office in February of 2020, the 2 trials that had started were quite advanced SRC before Justice Azlan, and Tanore, prosecuted by Sriram, just starting before Justice Colin Secura. And then all the other cases were put on the back burner for the practical reason that I gave. And then I just checked the online. According to the report, when the DNA was given, the trial only actually started this year, in 2024. Now let me just comment, and it's in 2024 that all the obligations of the prosecution to start the trial began.
I want to ask you about this IPIC case, because one of the things that have been widely circulated is the so-called internal memo from the Attorney General's chambers. The charges were laid on this case in August, on the 23rd of October.
Oh, it's October. It's
yes.
October.
Yes. But in September, this memo is from it says the internal memo, Attorney General's chambers, was dated 10th September. And in
of which year?
2019.
1 year later.
Yes, 1 year later. In this memo, the prosecution team, head of prosecution, Tuan Manoj Kurup, head of prosecution, and the people with him who were looking at all these charges seemed to admitted to you that there was actually not sufficient evidence to support these charges. That all the witness testimony that they looked at gave them the impression that there was really no grounds for you to charge. So my question and of course now Najib's team is using this so-called memo that was leaked, and incidentally it has never been denied officially by the AG's chambers. So the impression out there is that it is valid, it is real, but Najib's team is now using this memo to strengthen its charge that there were really no grounds to prosecute him, that this was all part of a political vendetta, that you were just going after them because this was the agenda of the government of the day. So my question is, were you aware of these views, and why did you overrule your prosecution team?
Well, I cannot remember being shown that memorandum at that time or ever. In fact, still today I have not seen it. But this is what I will tell you of the practice and culture in the AGC. Now, all the 1,600 lawyers in the AGC, and particularly those who are doing criminal DPPs and the Senior Federal Counsel, they are making decisions at their level daily in respect of litigation because the system is decentralized. Now, as Attorney General and Public Prosecutor, only a tiny number of decisions are made by me on behalf of chambers. That's how the system works, because otherwise it will break down. So of all the decisions that I made, and I must have made hundreds of decisions over the course of 22 months, civil and criminal, when I made those decisions, it will be communicated down the line, sometimes or sometimes not, sometimes it's confidential. In none of the decisions that I took was there ever, after I taken the decision, not before there'll be discussion, we are lawyers, we argue and debate and whatever, but after the decision is taken, which is why I said the charge was in October 18, the letter is September 19, 1 year later. Never in my experience did any officer come to me and say, look boss, you remember that decision you took? Can we review it? Can we have a second thought? Can we look at it? Never. That is again not the culture of the AGC. If the boss has decided, they all follow it. So I never saw any memorandum from anybody telling me to revisit any decision. Now what would happen is, typically the defense lawyers send representations to the public prosecutor, to the DPPs for all their cases. So at this moment, a lawyer acting for somebody who's been charged for rape in Bentong, that lawyer would be writing to the AGC and saying, please reconsider the case, drop the case against my client, Miss X. So those representations come in daily because of the thousands of cases we do. But they never reach my level. It's always at the ground level. And more importantly, there was no representation to my memory that reached me on this case. But more importantly, Sri Ram was the head of that team. And he was alive. He was with me in September 2019. If Sri Ram had received this memorandum, and I know Sri Ram well, Sri Ram would have thrown it in the dustbin. I mean, Sri Ram was a very strong, domineering lawyer, very confident of his ability. He would have given them a scolding and said, am I interested in your opinion? I am leading the team. You either get off the team or stay. So they would not have done it. And even if it had been written, it would have gone through Sri Ram, because they all know, everybody in that team knows Sri Ram is in charge of the IPIC case, as he was in the Tanore case, as he was in the audit report case. So I never saw that letter.
Do you think that's a valid argument that they couldn't declassify? So the question that the man on the street is asking, if you couldn't declassify, why on earth did you bring the charges against him? Surely you must have done that homework before you went forward.
Correct. So let's start with the Official Secrets Act of Malaysia is 1950, done by the British, copied from the England in 1911 during the First World War. It's been exported across the world. So the Official Secrets Act allows a minister and a senior civil servant in a particular ministry to do two things. One is to classify a document or information or material as secret, and the same minister and the same officer can declassify. So one section, I think it's 2A, allows them to classify, as another subsection 2C allows them to declassify. And of course, there are some documents which are regarded automatically as secret, which is cabinet papers and national security documents. But ordinary documents, there must be classification. So the first point is, the power to declassify is there. But more importantly, coming to a criminal prosecution, now when you do a trial where the government is the plaintiff in civil suits and the government to the public prosecutor is the prosecutor, and in order to succeed in either litigation, they have to rely on government documents. In other words, if the government does not produce the documents that will strengthen its case, it will lose its case. So it is in the interest of the government which sued or charged to produce those documents. It's within your control. So, for example, all the white-collar prosecutions involving... So let me give you an example, like Harun Idris. The famous case of Harun Idris in the 70s. Again, involve cabinet papers and things like that. There would have been declassification. So, declassification is a normal thing that happens in chambers when there are white-collar crimes involving government and government documents. So, as a matter of course, it could have been declassified.
But why didn't it happen in this case?
I don't know.
So, Nades, Nades, the columnist, he wrote an interesting article. He asked the question, was it incompetency or conspiracy? And he seemed to be making the point that, this excuse that they could not declassify was just a cover, was just a convenient excuse to drop the charges. How valid is this question that we were not able to declassify, therefore we cannot proceed with the case? Do you see that as a valid argument?
Well, I think from a bureaucratic point of view, the process starts by the lawyer, because it could be civil or criminal, the lawyer in AGC, DPP or Senior Federal Counsel, exercising his judgment and saying, I need these 5 documents. I need these 5 currently classified documents to win my case. It's within my control. I've seen it. Nobody else has seen it. I need to produce it to court. So that's the first step. He must make the judgment call. Then once he makes the judgment call, he has to communicate with the minister or the KSU, because it could be an agriculture, it could be a rice plan, rice issue, go to Minister of Agriculture. It could be education, you go to Minister of Education. Finance, so you go to the right ministry. And then there will be some dialogue going on, and the civil servants may say no, but if finally the lawyers say, look, we in our opinion, it has to be done, it will be given. It may just delay a bit. And if finally, I never had to do it, but finally, if it was under my term, I would say, as the AG, I would ring whoever it is and say, look, can you please declassify it, and I want it done in 5 minutes or by tomorrow morning, because in my opinion, I need the case. Yes. I need the document, and it will come.
And it's been done. I'm not unfamiliar with the Official Secrets Act. Even cabinet decisions, which are supposed to be top secret and under the Official Secrets Act, have been declassified. Yes. So, I personally, I tend to agree with Nades that something doesn't smell right.
Yeah, I mean, if you look at the situation, the person who is the AG now was the prosecuting officer when Zahid was given his DNAA, right? And he is the same person who would have to take ultimate responsibility for not producing these documents in court and making sure that the trial goes on. So, and he was actually the Prime Minister's appointee for the position of AGC. So from there, one can make a lot of conclusions.
No, but you see, that's why, and I'm not going to comment on all those things, because it's not fair for me to comment on either my predecessors or my successors. That won't be fair. I just don't know the facts. But it comes back to the absolute obligation in 2024, in the 21st century, that you have a duty to disclose to the public. So the 35 million people in Malaysia, 35 million Malaysians are entitled to say, why did this happen? And the only people can do it is you either have a press statement, which was my preferred, because you control it, you draft it, or you have an interview. Because if you absent either a press statement or an interview, there will be speculation. So we need public statements.
Can I turn to another of the famous or infamous DNAAs, this time involving Zahid Hamidi, whom, as you know, was charged with breach of trust, corruption, money laundering. The case had advanced. It was charged when you were AG, right? Yes, I charged him. The case had moved along, 77 days of trial, 114 witnesses, and then suddenly the charges against him were withdrawn, as you know, and the judge was obliged to give him a DNAA. You might remember it caused such an uproar. People were really furious. While the AG refused to say anything, the Prime Minister, Anwar Ibrahim, said that the charges against him were, I quote, questionable, not carried out professionally, and were politically motivated. The PM also said the charges were so flawed that it bothered the former AG, Attorney General Harun Idris, that he felt he had to dismiss it as one of the last things he did
Idris Harun.
in office. It sounded like the Prime Minister was publicly rebuking you, and you never said anything.
Actually, I can't remember him saying that, but I'll come back. But I think what I would say is that the most important thing about the Zahid case is that it involved taking money from charities. I think there's over 200 million to the best of my memory. And we called, I don't know any number of witnesses. We had a terrific deputy DPP in-house, Raja Rosila. She was absolutely terrific.
Yes, who was replaced.
Yeah, later, yeah. So she was terrific.
At the last minute.
Later, much later.
Yes.
And then most importantly, defense was called. Now, one of the problems about the criminal proceedings, as opposed to civil, is that a prosecutor has to ensure that when he completes his case and closes the case, must be aware that the defense will always exercise its right to say the prosecution has not proved its case. And that is a tough challenge. Any prosecutor will be concerned about that. And yet the defense was called. And Raja Rosila continued. And the defense called any number of witnesses. I don't know how many witnesses they called. And then it was going on slowly. And then one fine day we read in the press that Raja Rosila has been replaced or had resigned or something.
Replaced.
I can't remember much.
She was replaced and she refused to say anything about it.
Yeah, correct. And now she's in the bench. And then she was replaced by somebody else. So to say that there was no case is absolutely without legal or factual foundation because defense was called.
I think, in fact, the DPP at that time, who was in charge of the case, is the current AG.
Oh, I can't remember.
Yeah, he is the current AG, and he actually asked for a DNAA, although the judge has ruled that there was a prima facie case against Zahid. So that is what was extremely surprising about the whole thing. You know?
Yeah. And if I remember correctly, one of the reasons that was mentioned was that they were going to set up an RCI to look into your book and you and the whole thing. Whatever happened to that RCI?
Well, let me tell you, to the best of my memory, my book doesn't even mention Zahid's prosecution. If it had, it may be a one-liner. And so far as the RCI is concerned, I mean, I'm quite happy till today there is no RCI, but they had a special task force looking into it. But can I also say that you asked about the Prime Minister's remark, which I'm not hearing, but can I say that Dato Sri Anwar Ibrahim, our PMX, his wife was the Deputy Prime Minister in the administration I served. His party was a very strong constituent party in the administration I served. He was very much in the public news, Anwar Ibrahim. And I met him a few times. We met each other, we know. And I'm surprised that if that was his view, that he never came and said to me, look, Tommy, I've been talking to people and maybe your case against Zahid Hamidi is not strong.
Did you ever talk to him about the case or anything?
No, absolutely not.
Did anybody ever call you to ask you for your views?
No, absolutely not. So the first comment I would make is he was a member, it was his administration. And now 4 years later to say that, I'm a bit surprised.
One of the things that is of course going on right at this time is the $2.27 billion 1MDB case that's going on right now.
The Tanuri.
Yeah,
yes.
And the case that's going on right now. And I was just looking at some of the press reports, and the former Prime Minister suggested that he, like the current Prime Minister, had been punched, blindfolded and handcuffed, metaphorically of course. He also makes the allegation that he was robbed of the ability to defend himself properly, and that he still remains clueless as to the actual charges against him. What do you make of these allegations? Do you think all this is just to lay the groundwork for yet another DNAA? Is that coming down the pike?
You're talking about the witness statement he's reading out in court right now.
Yes, the one that he's reading out right now.
No, but you see, I would look at it this way, that when we always took the position that we had a very strong case, we in the prosecution, and the reason we were confident was that we had a lot of contemporaneous documents and the paper trail, which we got from mutual legal assistance from other countries. So once you've got the evidence, and both with witnesses and paper trail and documents, you know you're going to win the case. So just because of proving it, it's painstaking, laborious, but you call witness and prove it. And conversely, the defense also knows that they have a weak case because they are facing documentary evidence with signatures. And so when you have a weak case, you turn into drama and other things. So I am always happy in the adversarial system when my opponent and the other party goes off tangent like this.
Yes.
Instead of sticking to the what are your defenses to our claim against you.
One of the questions that Najib raised also, which I think has created a lot of speculation, is why were charges not brought against the Bank Negara governor and family, because they Najib claims were involved in the 1MDB scandal?
I think that's a fair point. What we would say is our resources were stretched at the time. So I've already told you that we had, against Najib, we had 5 charges in the one, all arising out of 1MDB. SRC to some extent indirectly, but the other 4 were 1MDB. And then we had against Zahid, Hamidi and a few others. So coming insofar as the 1MDB was concerned, my judgment call was, let's go for the main players. So I charged what you call Jolo, his father, but it couldn't go anywhere because they are not in the dock. Charged Goldman Sachs, charged Roger Ng, Timothy Leisner. So all the big players were charged. And then, of course, because of the trial starting, then my plan would have been, if the government had not fallen, would be then to go down to tier number 2, which would be the directors of the companies and other people. That was the idea. But definitely starting at the top, because otherwise it won't be fair. You cannot go for the small fish when the shark is on the top.
So am I correct in assuming that you didn't rule it out?
Of course not, absolutely not. No, of course. And the reason is we got a lot of information about her husband in Singapore, and we got the money back. That came out. And I think I can't remember whether we made a press statement, but we had to go to the Singapore courts. The government of Malaysia appointed a lawyer in Singapore. We went to the courts of Singapore, and the courts of Singapore gave permission for MAS, the Monetary Authority, to send the monies. And the interesting thing is, the monies were parked in Zeti's husband's name. He didn't object. He accepted that it was Jolo's money. So that is what happened during our time. It was a question of following up.
I think the earlier questioning about questioning of the Bank Negara governor, it seemed to indicate that everything was like sort of cleared as far as this was concerned. So in the Tenore trial itself, and that the latest one, when Najib is reading out his witness statement, he seems to imply that that the Bank Negara governor gave a rapid approval for the foreign exchange transaction. So which, I mean, to me, it doesn't seem like an offense. It might be maybe regulatory oversight at worst, So this was a Ministry of Finance company, wholly owned by them, and administered by the Minister of Finance directly, who was the Prime Minister at that time, who had authorized this transaction to take place, So how much choice did the Bank Negara governor have over these kind of things now?
Well,
so it's not so...
I don't know the facts, but what I would say is, you mustn't forget the governor of Bank Negara is also under the law, the controller of foreign exchange. And that's part of... So, I don't know enough of the facts of this case, of the Tanuri, to tell you. I know that the prosecution called her as a witness, this after Sriram had passed away. So, I cannot comment on it.
This was ostensibly for an investment in some kind of an oil field overseas now, a strategic investment.
But I see that allows me to say something which I was going to say but I didn't, which is, people forget that as lawyers, all the 1,500 people in AGC are lawyers. We are not investigators. So when an alleged crime takes place, somebody lodges a police report or MACC report. The police investigates, or the MACC investigates, whichever the enforcement agency. They investigate, and then they give us what do you call IP, the investigation papers. Only at that stage does the lawyers, the AGCs come in. So unless we get the IPs, we can't do anything. So and that was, there were a lot of criticism by UMNO in particular. Why did I only charge UMNO people or whatever? The answer is it wasn't my decision. If the files that come to me, or which the AGC has no say, it is coming from MACC or the police or whatever, whoever, they come and give you the files. We can't say, why are you giving us the file A? What about B? We have to do our job. So the files that were given to us were determined by others.
So which means if the investigating authority is ready to ask you all to press charges, they must have seen the secret documents as well, isn't it?
Oh, of course, of course.
Then it's not their responsibility to get those secret documents, you know, so to be...
No. The declassification is between AGC and the minister.
So which means the documents have actually been seen but not declassified.
Of course, we have photocopies. Of course, we have the photocopies. We know it. In preparing the case, they, while investigating, that is they meaning MACC and the police, they have photocopies. We, the lawyers, have photocopies.
So it's purely a procedure.
But in criminal cases, you have to produce the original. And the original, when it's under OSA, you have to get a declassification certificate. So there will be a certificate classifying it and another certificate declassifying it. And those you have to produce in court.
Can I ask you about this? When you look back over the last 2 years in particular, it seems that some of the big gains against corruption that were accomplished by the first Pakatan Harapan administration under Dr. Mahathir, charging several bigwigs for corruption in particular, are now being undermined, weakened by a PH-led administration under a Prime Minister that came to office offering the promise of reform. And now it seems like, DNAs are flying around. Some of those who were charged and with all kinds of, dozens of counts of things are now in high office, and some of them are being turned into heroes. How disappointed are you?
Well, I think I'm a little surprised at the parties, because if you look at the PH government of Dr. Mahathir that I served and the PH government of Anwar Ibrahim, the constituent parties are very similar. The DAP is common to both, Amana is common to both, PKR is common to both. So
the only difference is UMNO.
UMNO is coming, yeah, but yes, that's correct. But UMNO has got a small, there are only 25 seats in the parliament. They're quite a small, I think DAP has about 40 seats. So even if UMNO is there, one gets the impression that the PH aspects of the coalition party is not exerting itself. So all these people who were, there are any number of members in the cabinet, current cabinet, who were members of the Dr. Mahathir cabinet, who whenever they saw me and all were very excited. They said, you are doing the right thing, charge and all, but they are silent now. I can't understand that, so that is disappointing. And then of course, the other thing is on reform, because I always said that part of the PH reforming government is that, and I always called myself a reforming AG in a reforming government, and part of it was law reform. And I accepted that unfortunately in our 22 months, our track record wasn't impressive. We had done the constitutional amendment to allow under 18 to vote. That was done during our time, and we also presented the bill to keep the Prime Minister's term to 2 terms, which of course the subsequent government then withdrew. But otherwise, and we started the death penalty, but it was pretty meager and pretty disappointing. But what is sad now is that in this PH number 2, first of all, there's no talk about reform. You don't hear the term reform RC at all. That's just sent to oblivion. But more worrying are the bills that they are presenting, like the Mufti bill, then the bill about the Printing Presses Act, the threat to get online. And I gather there was a demonstration, or I would say there was a handing over by some journalists of a memorandum yesterday. And then
Do you find that very worrying, all these new legislations that are being proposed?
Well, I think they're all unconstitutional. I mean, that's
unconstitutional.
I think so. I think they are. But until a court decides, but that's something separate. But it's certainly the antithesis of reform. So not only are they not on the reform road, they are behaving the opposite of reform, and that is sad.
Okay, I think our time is running out. Do you have any regrets of your time in office? Was there things you would have done differently or not done at all?
No, I've got no regrets. I think the disappointing thing is nobody expected the government to fall after 22 months.
You think it would have been very different if Dr. Made had not resigned and continued, and you had continued as AG?
Well, I think I can't answer about Tun, Doctor. I think they had to have a handover, because that was the promise between Tun and Dato' Anwar, whether it's year 3, year 4, whatever. And I'm not going to comment on that. That's a political decision. But I think what I would say is that when I was offered the job by Tun, and he said it's a 2-year contract, so I said, Tun, I got a lot of cases to do, a lot of litigation, and you know how slow things are. How can it be 2 years? Nothing will. He said, no, don't worry, it will be extended and whatever. So I knew it will be at least for the 4 or 5 year term, in which case you can see through the litigation. So that is frustrating as a court lawyer, that you start a case and IPIC disappears, Goldman Sachs disappears, a lot of these cases. So it's a bit frustrating, because you would have done it differently. And that's each lawyer would say they would do it differently. Because at the end of the day, a lot of law is art. You know, it's not science. Law is not science. Law is not black or white. Law is very much grey and nuances. And so you can contribute yourself differently.
All right. Well, Tan Sri, thank you very much. It was a pleasure having you on Straight Talk.
Thank you for having me. Thanks, Guna.
Welcome. All right. Yeah.